Now, I can go? Okay. I'd like to call the meeting to order. This regularly scheduled meeting of the Board of Architectural and Engineering Examiners is taking place in Conference Room 1A of the Davy Crockett Tower at 500 James Robertson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the board website on August the 4th, 2014. I would like to remind all the guests to please sign in at the table back there. And I guess we only have one guest today, don't we, right now? That's right.
Only one.
Candy, I think we know you, so you don't have to put your name on the record if you don't want to, but yeah, yes, you do. We have to be more formal with that, I'm sorry. All right, any announcements?
I guess I could announce at this point that the appearance by Wayne Wagoner about delegated design of fire sprinkler systems, that's going to be deferred to a later meeting since Ricky Bursai could not be in attendance today as our lone mechanical engineer. We felt it was important for him to be present for that issue, so that's going to be deferred probably to the October meeting. It's tentative at this point, but that's our plan.
I'm sorry, I skipped the roll call, Wanda.
Oh, oops.
Yeah, I got ahead of myself.
Susan Ballard.
Here.
Hal Balthrop.
Here.
Wilson Borden.
Here.
Robert Campbell.
Here.
Jerome Headley.
Here.
Philip Lim. Bill Lockwood.
Here.
Rick Thompson.
Here.
Frank Wagster.
Here.
Ricky Bursai. Ron Bold.
Here.
And Stephen King.
Here.
Quorum.
Are there any other announcements now that we've done the roll call? Okay, are there any changes or additions for the agenda? Other than we're going to be eliminating Wayne Wagner from the presentation? Is that it? Okay. All right, we'll move on to the consent agenda. Mr. Cothran?
On page 77, you have the draft of the June 2014 minutes for your approval.
I move they be approved as submitted.
Second.
Motion and a second. Any other discussion? No? All in favor signify by saying aye.
Aye.
Opposed? The same. Motion carries.
Page 87, you have complaints in which the respondents were disciplined in another jurisdiction. The discipline was less than a suspension or revocation. So in accordance with board policy, we issued a letter of caution and recommend closure. You can just vote on these as a group.
I get a motion?
So move.
Second.
Second. We have a motion and a second. Any discussion? All in favor of the motion signify by aye.
Aye.
Opposed? The same. Thank you. The motion carries. There we go.
Have a paper agenda at your positions too. So.
Yeah, okay. That was blue, okay. All right, we're moving on to professional society reports. Our one guest.
I'm Candy Toller with the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. get the opportunity to make a report. There are several things going on for the engineer associations, and the big one is our engineers conference on September 25th and 26th, and we appreciate Hal and Laura doing a session which will kind of be open. I'm thinking we'll probably want to talk about the QBS rule because they'll have more questions, but there may be other questions too. And I'm pleased to report that a bunch of engineers, like 150 of them, are working with TDOT on various things to improve the processes at TDOT, and we're doing the same thing with the state architect, and in that case, the architects, the engineers, and the contractors are working together with state agencies to improve construction. We're offering the PE Civil Exam Review again, starting on Monday evening, and I appreciate John's posting that so that people know it exists. And that's really all, unless you have any questions for me. Oh, and I guess I should say Ashley is sick. She is not here, and as I was walking over here, she said, you know, I really don't have anything to report right now. Her mind wasn't wrapped around that.
Got over the convention.
Well, no, I think she has strep throat.
Oh,
So it's a little worse than that.
ah.
Okay,
Okay.
thank you.
Okay, the delegation of design of fire sprinkler systems has been Xed. We'll move on to the legal case report. Rob?
Page 88.
88, okay. It's, time for the good stuff there, Mr. Lim. Got all of 3 cases. So I'll just read them into the record here. Number 1 has 3 different numbers. It's all the same matter. And these complaints were presented originally. Well, they were presented several times. June 12th, 2014, February 18th, 2010, 2010 meetings as follows. This is an old one. The complaint alleges the respondents, licensed individuals and entities, committed misconduct in the practice of engineering relative to several activities. Generally, the misconduct allegations, what a day, stem from contract issues, misrepresentation, and unprofessional conduct. Complaint history on the respondent professional engineer. The board accepted a recommendation at its February 2010 meeting for a review by an east or west probable cause. Mr. Henderson back then did the review. That review, the board approved an informal conference for June 16th in 2010. 17th board meeting of 2010, the board authorized a formal hearing, considers this matter a priority for its consideration. 4 years ago. June 12, 2014 meeting, the board authorized a consent order for a civil penalty of $1,000 and a requirement to take and pass the board's law and rule exam. Updated information. The respondents requested an informal conference, which we let them have on August 7th, and Mr. Campbell was there. Let him expound upon what he heard and learned and what he thinks.
Thank you. Let me digress just a little bit to this TV show Happy Days. And there was an instance on there where Arthur Fonzarella was asked to admit that he'd made a mistake and he couldn't bring out the word wrong. So he kept saying, and so I'll say I'm mistaken instead of I'm wrong. But we did have the complainant, the registrant there at the meeting. First of all, he is very competent. During the course of the interview, that came across very clearly. Several things that were not in the original file, such as there was a mediation effort where he agreed to have other engineers look at his design and was going to pay for that. were not in the original file. The complainant didn't even agree to it, but didn't sign off on it. They've not heard from the complainant in about 5 years relative to this settlement issue. They did use hydraulic piles around the perimeter and in a girder that they had put in, and used concrete spread footings, which was what was recommended by another engineer. Again, looking at the plans, that was not obvious. They went through a lot more of the complaint history with this gentleman. They went through different things, and some of my original assumptions were not, based on looking at the file, were not borne out. So what I would like to see us do, there were actually 2 areas in the structure that were exhibiting movement. The rest of the structure seemed to be in pretty good shape. I'm talking to this gentleman. It appears to me that his issue is more in not in competency and not in doing something unethical. It's in communication on solutions to problems and reasoning for this happening. I just don't think he ever broke through to the homeowner, or this may have been one of those clients that no matter what you did was not going to respond. But what I would like to do is I would like to amend my original recommendation to remove the $1,000 penalty, but still send a letter of caution to the registrant, because I do believe that if he would have handled a few things maybe a little differently, maybe with a little bit more of a velvet touch, if you. But and that being said, they were very responsive. Every time the gentleman called, they came out and tried to make adjustments and tried to do things. It wasn't like he left the project, which is sort of what the information that we had seemed to indicate. He came out to kept coming, and he offered that during the mediation and during other things, that he would come out at any time, no cost to the person, and do it. So I think this person, again, I think there was a lot of communication thing that he probably could have done better, and maybe some offers of some different solutions that I think they went over internally but never came back to the client and said, well, we've looked at this, we've looked at this, we've looked at this, and we don't think this. And, that was never communicated back to the client. I think that caused some of the original problem. But based on what we found out subsequent, that would be my recommendation: a letter of caution and removal of the $1,000 penalty.
Is that a motion?
Yes, sir.
Offered by you? We have
I
a
will second that
We have
motion.
a second. Any further discussion? Yes, sir.
Campbell, the fact that the registrant, you appear like the registrant could not communicate back, is that more of a personal issue, or is it more professional conduct?
Well, I don't know that it was professional conduct. I think it may have something to do with professional conduct. It's just hard to separate the two, Mr. Lim, is that I don't know if it, because we weren't there, we didn't hear the conversations. I think it was more incumbent on him to follow up a little bit more formally than maybe he did, and I'm not sure exactly where to split that up. So he's also got a little bit of a complaint history on different things, and that seems to be kind of a common thread during that complaint history.
But to add to the request to defend the registrant to take and pass a law and rule exam too, in addition to what you have?
Well,
Without a warning?
yeah, but I don't know that he violated. He was on the edge. I don't know that he violated our laws and rules. I think he split some hairs on it. And if this was, I thought, a violation, I would probably have added a penalty as well as the law and rules to this. But I think it was more of borderline professional conduct in some areas.
But I think didn't you say that earlier that he had some problem in the past before, correct?
Yeah, on this particular item, he did. And then there was one other item that he had a it seems like he's got that.
Just out of curiosity, that's been going on for what, 3 or 4 years? Problem been resolved?
Well, see, that's the other part of it. In the last, I think it's been for 4 years now that he's not heard back from that property owner. So the assumption either the property owner has moved or the problem, the last whatever he did fixed it. So, but it was an old complaint that we had, and again, we have to act on the complaint at the time. But there was the mediation was omitted from this, as well as some of the other things that he had done for solutions to the problem.
Mr. Chairman.
Yes, sir.
I probably should have asked this question a long time ago, but what are the consequences when you issue a letter of caution? Does that go into their file?
Yes, sir. That's strictly what it is.
Normal discipline, and it goes in their license file, but it's not broadcast to the public.
Not reported to other entities.
Something else ever happens and we get another complaint, we can consider that.
That's the least of the letters.
Instructions at least, but he's been licensed long enough to where he doesn't need instruction. He needs.
Table in a second. Any further discussion?
Mr. Chairman, the reason I brought up law and rule is because if we have been pretty consistent. Anytime when somebody doesn't understand what they're supposed to be doing, in my mind, again, I could be wrong, that, if he has a, wondering what would that do to the general public, the next project he goes on, is he going to continue on to have issue not communicating with people? That's why I premises my question is it a more personal issue or more professional conduct? As professional, we are responsible for the public. We are responsible to communicate. I rest my case. Thank you, sir.
Campbell, would you entertain that amendment to your motion?
I would, but again, I'm not sure that I mean, I understand exactly what Mr. Lim is saying, and I think this may have been one of those situations where we've all dealt with a difficult client that it didn't matter exactly what he did tell him, it would have not been received. That's hard. That was hard to differentiate on this.
Was that offered as an amendment, Philip?
Yeah.
Oh, okay. I didn't hear that.
Robert, you're okay with that amendment, or?
Yeah.
I mean, yes.
Yeah, we can, I mean, if I'm okay with it, I'm not sure that it's necessary. This guy's been drugged through a lot over the last several.
If you're not willing to accept it, then they won't.
I mean, I'm okay with it, but I don't know that it's necessary. I'm ambivalent. Is that a Yogi Berra term? Ambidextrous. I'm ambidextrous towards it. Okay, well, let me make this,
I'm conflicted here.
okay.
He accepted it.
I accept
All
to
right.
take the laws and rules exam. I'll
Okay.
just make that clearer.
I feel compelled to point out, this particular respondent has recently taken and passed the law and rules exam in regard to a separate matter. So probably not necessary in this case.
Like the new information, I'd like to withdraw my friendly amendment. Thank you.
Thank you, Mr. Lim. All right, we have a motion on the table and a second. All in favor signify by aye.
Aye.
Opposed, same. Motion passes.
I've just put to bed the oldest complaint we have, so we're
Sure, I'm putting a big
back in
X
this
by that.
decade. Okay, number two's got 3 different characters in it. Same thing. Complaint alleges possible misconduct in connection with a home inspection that resulted from damage due to road construction, a potential violation of our rules. Respondent number 1 was first licensed in July 2000 with no complaint history. 2 was licensed first in June of 2004, no history. And number 3 was first licensed in 08 and no history for him. Now, this was sent to Ricky Bursai for review, and he did review it, and he sent me his comments. So I'm going to read you his comments, so just imagine Ricky's voice in your head. Okay. After reviewing the complaint, the responses from the 3 respondents, and additional information supplied by the complainant, I recommend that this case be closed. End it there, but I'm going to go ahead and give you his reasoning. One of our rules possibly violated here, having to do with misconduct, was being considered because the complainant thinks that the engineers involved collaborated on misrepresenting their identity during an inspection of the complainant's house. That might not make much sense. What the guy's saying is, you might have to with this. This guy has a house way out in the country. He wanted a home inspection. Somebody showed up to do the home inspection and told him they were somebody. Not who they said they were. So he opened a complaint saying this person showed up and said they were somebody they weren't really. That's pretty much it.
Yeah.
His conduct is, he said he was somebody he wasn't. But anyway, doing our due diligence, we sent it out for review. After review, I believe it is highly unlikely that the person who did the inspection was anyone other than who they said they were. The respondent is who the engineering company sent to do the inspection, and he said he did the inspection. No proof presented to the contrary other than one person's memory and subjective eyewitness claim. That's what that room's for.
Time out. He's a timeout.
Yeah, close it, lock the door.
There's some proof presented that leads me to believe that the misrepresentation never happened. Eye color, hair color, build, weight, employees' account of the engineers. Point number 2. Another one of our rules in play had to do with misconduct because of the claim that the engineer doing the inspection was under the influence of alcohol and marijuana. I see no way the board could prove this, and the fact that the engineer did an inspection on the roof could be considered evidence to the contrary. Up on the roof. Age and condition of the complainant's house, and considering he has a 5-year-old claim of damage done to his house in 2009, it's not unreasonable for an engineer doing an inspection to come to the conclusion in a report to the insurance company client that the claim of damage in 2013 from roadway equipment is not conclusive and would be difficult to prove. Old damage is not new damage. House on Google Street View regarding its construction and location leads me to think that it is reasonable that an inspecting engineer might come to the conclusion that the risk to the public was not out of the ordinary when inspecting an old building with a brick parapet. There's no evidence presented that the A&E Board can assess and come to any conclusions. In order to prove that any of our rules have been violated, it would take a level of investigation that is beyond our purview. If the complainant wishes to pursue this, it is more appropriate that he hire his own structural engineer and/or investigative attorney. I recommend the case be closed. I would amend that to say let the case be dismissed, so it goes away forever.
Motion to accept the recommendation.
So move.
We have a motion.
Could you restate the motion? Because there is a distinction between closed and dismissed.
I move that the case be dismissed.
All right, we have a motion and a second. Any further discussion? All in favor signify by aye.
Aye.
Opposed, the same. Motion carries.
Third and last case is a garden variety practice on an expired license. The complainant alleges the respondent or PE sealed but did not sign across the seal a certification letter and submitted it to a code enforcement office while the respondent's license was expired. Respondent's license originally expired on May 31st of this year, was renewed on June 28th of this year, and will expire again in 2016. There's no complaint history. The respondent responded to the complaint stating that the original renewal got misplaced and so on and so forth. Further, the respondent states that the document that was sealed did not require a seal and signature, but the client requested a seal. That's the only thing I really take issue with. If the authority having jurisdiction says you need to seal it, then you need to seal it. So, the recommendation is authorize a formal hearing with authority to settle with a consent order for a civil penalty of $500 and a requirement to take and pass the board's law and rules exam. Because when he did seal it, he was expired.
Is there a history of such occurrence with this? Okay.
No, but this happens fairly frequently with us. People expire and then they stamp things and while they're expired, and this is what we typically do. We assess the penalty and a law and rule exam. And
Licensees, we were getting used to
I think you're confusing renewals with the professional privilege tax. Yeah, renewal notices we still mail. Yes, we do, yeah. Privilege tax, they've discontinued that practice, yeah.
All right, we have a recommendation from Rob.
So move, Mr. Chairman.
So moved. Second. We had a motion and a second. Further discussion? No further discussion. We'll vote. All in favor signify by aye.
Aye.
Opposed, same. Motion carries.
Do you want to go back to your staff?
Chairman, we have two new society members here. I guess we can go back and finish the.
Yes, we will. Thank you. Now that we finish our legal report, would the society members like to introduce themselves and make any report to the board?
Good morning. Apologize for being late. Thank you for working me in. I'm Don Baltimore with the Tennessee Interior Design Coalition, and my report will be very short. We are just looking at the next session and ready to work with the board and the other associations to protect the industries and professions. We do have a statewide convention. The American Society of Interior Designers Tennessee chapter has in Nashville October 10 through 11. So if we finish up at Montgomery Bell Retreat, we can just stop by Nashville and the ASID convention on the way out of town. So, thank you.
Good morning, Mr. Chairman, members. I'm Nathan Ridley here on behalf of the Tennessee Architects. Our annual meeting is coming up. It'll be in September in Chattanooga, the 18th and the 19th. We always welcome your participation. Alan Jones, our president-elect. It's kind of interesting to me to give that task to the president-elect to plan the annual meeting, but we've done that historically, and he's from that neck of the woods, and I think it's not sure what Candy told you, but I always like to give you a little bit of flavor of the election process. We've just survived you remember that we really have two elections on August the 7th. You have the general election for local offices, then you have the primary election for state and federal offices, and Senator Alexander about 50% of the vote on the federal level. And at the state level, several of our legislative friends won't be with us anymore. So y'all remember that we don't have formal term limits, but I've always thought that we have term limits every 2 years. And during the election process, and 8 incumbents were defeated this time. And it seems like the more heated elections do occur at the primary level now. So that's kind of interesting to watch on that level. Probably the election that got the most attention, and I encouraged our group to lawyer, but yes, question.
Microphone's fading in and out, Nathan.
Oh, I'm sorry. Oh, I think our thinking was that judges call the balls and the strikes, and it doesn't really matter who appoints you, so we were supporting the retention, and we're pleased that those 3 justices of the Supreme Court were retained. But that concludes our report. As always, we look forward to working with your staff and your members and participating, I guess, in the upcoming October meeting for the board at Montgomery Bell State Park. Okay.
Thank you, Nathan. Okay, back to the agenda. We have the director's report next. Mr. Cawthorn?
Okay, got several things to report on regarding national council meetings. Rick Thompson, Jerry Headley, Frank Waxter, and I attended the NCARB annual meeting in Philadelphia on June 18th through the 21st. We do have a report on that meeting later on the agenda. And several of us have been approved to attend the NCEES annual meeting in Seattle, Washington next week. Hal Balthrop, Philip Lim, Stephen King, Laura Reinbold, Rob and I will be attending that meeting. Also, I've been appointed to the NCARB Member Board Executives Committee and will be attending a committee meeting in Washington, D.C. on September 5th and 6th. Bill Lockwood, Jerry Headley, and I have been approved to attend the CLARB annual meeting in Reston, Virginia, outside D.C. on September 24th through the 27th. And Susan and I have been approved to attend the CIDQ annual meeting in Albuquerque, New Mexico on November 14th and 15th. And there's one more meeting coming up, as if that's not enough, and I think Rick's got to leave early because he has an NCARB committee meeting. He's on the, is it Professional Conduct Committee for NCARB? He's got a meeting this week in D.C. for that. We also are going to have another NCARB meeting on October 31st and November 1st. It's going to be the NCARB Member Board Chairs, Member Board Executives Conference, and that's going to be held in Indianapolis. That meeting is held every 2 years. I wasn't aware when I put together the travel plan for this year that they were scheduling that meeting this year because they've made some changes to their meeting structure recently. So since that was not part of our travel plan, I was going to ask the board for authorization to send either Mr. Thompson or a designee and myself to that meeting.
We'll
since it
make that
wasn't part of
motion
our
that
original
we
plan.
approve that travel request.
A second.
We have a motion to approve the travel request and a second. Any additional conversation? All in favor signify by aye.
Aye.
Opposed, the same. Motion carries.
Well, and I should point out, too, I think NCARB covers all the cost for that meeting, so it will not actually impact our budget at all. But we still have to ask for authorization in those cases. Other meetings, Rob and I met with representatives from the State Fire Marshal's office in June to discuss common problems that they are seeing and the plans review and referral process. Basically, we just haven't been receiving many complaints from them in recent years, so we're trying to sort of mend fences in a sense, and see what problems they're seeing and how we can assist them, how we can work together to protect the public. I got several administrative issues to report on. The Assistant Commissioner of Regulatory Boards, Bill Giannini, has been promoted to Deputy Commissioner and will oversee regulatory boards and consumer affairs in his new position. The Assistant Commissioner of Fire Prevention, Gary West, has also been promoted to Deputy Commissioner, and he will continue to oversee fire prevention activities. We're also working on improvements to our website. There's a new marketing director and webmaster in our department. Just met with the webmaster this week. So we're anticipating a launch date for our new and improved website in April of next year. So I think it's going to be a big improvement. Progress is continuing in the development of our new licensing system called CORE. And the anticipated launch date for that system is December 2014. You may recall from previous meetings I reported that eventually the system will allow us to have online applications, so rather than people having to mail applications in to us as we currently do. So that'll be a big improvement. That will not be implemented this year, but that's going to be a future part of that system. The rules approved at the August meeting last year are going to have to be returned to the AG's office due to a change in their filing procedures, so we still don't have an implementation date for those rules. I'm not sure, Rob, if they've been, I don't think they've. Okay, yeah, we're still not sure when those will be implemented. The status, oh, okay. That was a note to myself, sorry. The rulemaking hearing notice that was approved at the June meeting is still pending review right now. It has to be reviewed within the department, and I'm not sure who all reviews that, but it has to go through several layers of approval before we can actually file it with the Secretary of State and schedule the rulemaking hearing. So at this point, I'm not sure if the hearing's going to be scheduled in October or December. Probably December, Rob says, so we'll see. Rulemaking is becoming increasingly difficult, as you can see. So, also, letters requesting grant proposals were sent out this month, so we should have those for everyone to review prior to the October meeting. And invitations have been sent to all the deans and program directors for our meeting with educators at Montgomery Bell State Park in October. I also sent an invitation to ETSU since they have applied for CETA accreditation. And so far, 11 have responded that they plan to attend. So it looks like so far we're going to have good attendance for that meeting based on the responses I've received. I am working on our next newsletter. I've been holding back on that because I wanted to include our rulemaking hearing notice. But I may just have to go ahead and publish it without that since we're not sure how long it'll be before we can schedule the hearing. And that newsletter will include our newly adopted FAQs regarding qualifications-based selection. And I was just notified yesterday, Laura mentioned this to me yesterday, that Lipscomb's civil engineering program has received ABET accreditation. Really? Okay, well, I got an email from the dean.
good.
Yeah, I got an email from the dean yesterday, and he
good.
forwarded the letter from ABET.
Well, it was
Yeah.
ESP.
So I think they just
knew
got
that.
it yesterday. He was
Yeah.
excited, so he sent it directly to me. And their civil engineering program, based on the information I have, is now accredited, and that's retroactive back to October 1st, 2011. And I think we are still holding a few engineer intern applications from students in that program. We were waiting until they were accredited before issuing their certifications, so that's good news. Any questions about what I've reported so far?
No.
Well, I guess we do.
Mr. Campbell, you're first.
We have a request from the Engineer Club of Memphis about speaking engagement. What ever come out with that?
Yeah, I notified them that it was actually for an engagement this week, I think, wasn't it? As I recall. And we weren't able to send a representative for that engagement. So I informed them that we could send a speaker for a future meeting of the Engineers Club. I haven't heard back from them, so I'll just wait until I hear back.
Mr. Campbell?
You mentioned on your meeting with the fire marshal, were there any issues? Is there a schism or any kind of problem, or were they feeling like we're not acting on things they say? I'm just curious if that was something, or is it just we're doing that good of a job, or not that many projects coming through?
Rob, did you want to comment on that? What the fire marshal's office? Oh, they mentioned a few areas where they saw problems. Didn't it deal with atriums? I don't have my notes from that meeting.
Yeah, I don't remember.
Yeah, we've slept since then, so we
Yeah.
don't.
But they have problems that we, like John said, we haven't been getting complaints from them. On the chance that they just weren't referring stuff to us. They used to refer things all the time, and now they don't. But was it atriums that they were having trouble with?
I think so,
It rings a bell.
yeah. I'd have to check my notes on that,
We
but,
can update them at the October meeting.
yeah.
But the summary is they're just not seeing as many issues. It's not that they're not referring things to us, or I'm just,
Well, ages ago, they used to refer things like not signing the seal correctly. We used to get a lot of that. That used to be, it wasn't as much misconduct as just the things like that, and that dried up. But we haven't been getting the conduct stuff. They had trouble with things like UT Stadium and
Yeah.
things like that, but all those projects are done now.
Yeah, I don't know that it's necessarily that they're not seeing any problems. I think typically they try to resolve it through other means rather than referring it to us
Yeah.
as a complaint. And normally it's resolved
That's what I used
without
to,
resorting to that.
I used to try to get them to do that when I was their attorney, to try to fix the problem before it became a worse problem. And of course, we don't look at marinas anymore, so we don't get those.
So they are saying they're fixing them in-house, and
Yes.
it's not something that they're not sending them because they don't believe that, okay, that's all.
They only sent it to us if they were just, didn't know what they were doing.
Well, that's good for the industry then.
I did actually receive something from them just recently, so I think perhaps our meeting was productive. Maybe they feel that the lines of communication are more open perhaps than they once were. Yeah, so hopefully that was successful.
Hopefully, whenever they consider opening a complaint, they'll let John and I know, and we can come up and confer with them and see if it needs to be a complaint. Certainly it does.
Mhm.
But we don't want to open complaints that aren't necessary, because if it was my license, I wouldn't want a complaint opened against me that wasn't necessary. I don't.
John, I thought in the past, the board tried to really invite them to come to a meeting just for dialogue purposes, acknowledge them. I think we need to continue the relationship. Not because just for the sake of meeting, but I think just once in a while, I think it'd be a good timing for inviting them back, maybe in December meeting, just ask them to see, with all these things, situation, can you give us a good feel? 1 to 5 been great, scale of 3, and then just leave the open invitation to them, so.
Plan is that representatives from the fire marshal will attend the meeting when Wayne Wagoner makes his presentation, his appearance before the board. So that might be a good time to also just have a discussion with the fire marshal's office, with the codes enforcement at that time, or we can schedule it separately. But I know for a fact, I'm not sure if we do the meeting with Wayne Wagoner in October, I'm not sure the fire marshal will be able to attend that meeting. So if we do it in October, we'll probably definitely need to schedule a separate meeting with the fire marshal's office representatives, perhaps in December. But it's possible we might be able to do them together at the same time. But yeah, I think that's a great idea to meet with them occasionally.
Another question about that, y'all met with the state fire marshal, obviously, but, the ones that, there's a lot of plans reviewed by local codes enforcement. A lot more, I'm assuming, than the state fire marshal actually reviews. Has there been a change in the number of complaints coming from them also, or is that pretty much the same?
It's pretty much the same. I haven't seen any change in that. In most jurisdictions, we never receive complaints from. There's a few that we do, but I think generally there's a reluctance to submit complaints to our office. That's not entirely surprising when you consider the politics and such involved, but yeah, I think maybe where you're going with that is it might be a good idea to meet with some of the local jurisdictions as well. Yeah, and Rob and I have discussed that as well,
We're
that's
trying to assure them that we take complaints seriously.
right. Sure them that we take complaints seriously and that we want to work with them. We don't want an adversarial relationship with the building officials. And I do frequently am invited to attend the Tennessee Building Officials Association meetings where you have representatives from all over the state fire marshal as well as local codes individuals. And I usually do state in my presentations to that organization, usually every couple of years, I get invited to speak to that group along with the director of the contractors board. I always urge them to, communicate with us if they have any concerns and to refer matters to us if they see potential violations. On page 91, you have the number of licensure applications reviewed and approved for the past fiscal year for your information. Yes.
Matter of clarification, but my nerd self adds up numbers, and some of the numbers aren't adding up.
Well, that would be Wanda Garner's fault.
I love how quickly you did that, John.
Yeah, this comes up, I think,
Well,
about every meeting, doesn't it?
just the total number of engineering reviewed and approved is not,
Okay,
it's actually very high, which is why it caught my eye.
okay. Yeah,
It
you're
should
right.
be
that
about
is-
1,100.
You're right, that is kind of high. isn't it?
And then under architects, the total reviewed is 303, but the total approved was lower at 301. Again, that's my nerd self just shining through.
Error in Excel, I guess, with calculating. Yeah. Okay. Operator error, yes. Page 92, you have the number of registrants. Again, I'm not responsible for any mathematical errors in this report. And page 93, you have a list of our open complaints as of August the 6th, just a snapshot of our complaints. You'll see that our number of complaints has gone down significantly recently, only 19 as of August the 6th. Only 5 of those over 180 days old. All of those have had clock stopping action, as we say, where a formal's been authorized or a consent order issued, something to that effect. And 5 formal hearings are currently authorized to be heard by the board. I think that's dropped by 1 today, based on the legal report. So now it's just 4. And our percent on time in the last 18 months is 91%, which is well above the department's goal of 75%. And you have additional complaint reports following that report. Again, I'm not responsible for mathematical errors. And that concludes my director's report, unless you have additional questions or comments.
Comments, questions? Okay, then we'll move on to the Engineering Committee report. Hal?
Yes, sir. We did meet yesterday. We had quite a few apps to review, and they were successfully processed. One issue of note, we are seeing a consistent lack of information, I will call it, on certain applications. Because as we all do, we want to encourage and enable licensure, and also covered a number of NCWS motions. Registrants at the conference next week. One of the big issues being discussed is the uncoupling criteria for eligibility for sitting for the PE exam. And several states, and including in our region, Carolina and Kentucky, have, and I'm not aware of any others just yet unless John or Candy are, allow candidates for licensure to sit or be approved and sit for the PE exam prior to their acquiring 4 years post-qualifying degree experience. The challenge for us is going to be granting comity to those candidates if they apply for licensure in our state, because if they don't meet our criteria, we are by law not allowed to grant licensure in Tennessee for those candidates. Further, it kind of, in some people's minds, puts our in-state registrants at a disadvantage as well. So we will continue that discussion. We've held public hearings and comment opportunities. We're interested in seeing at the conference next week what other states are doing or what experiences they've had with it. Certainly one of the big umbrella objectives of NCWS is mobility of licensure, and trying to encourage people to seek licensure by being assured that they have mobility to practice their profession in jurisdictions equitably and evenly. So again, we'll continue that conversation. Another interesting related to exam on the fundamentals of engineering, John shared yesterday, and I may get him to repeat it, what trend we've observed, at least in our state, since the implementation of the computer-based testing. John, tell everybody what we're seeing, at least on this. Go ahead.
For the January through July period, we've had 200 applicants for the computer-based fundamentals of engineering exam. And typically for the spring exam, back when it was offered as a written exam in April, we would see around 500 to 600 candidates. So we have seen a dramatic decrease in the number of candidates in our state. Most other states have seen a decrease as well, not necessarily as significant as our decrease, but just about every state has seen a drop. A few states have seen an increase. And the directors I've talked to, they're not really sure why they've seen such an increase due to the increase in cost of the exam, but for some reason they have. But for the most part, there's been a drop in the number of candidates. I think overall greater than was anticipated when the change was made.
On that point, John believes, and we're going to discuss with the deans in the October meeting, that the cost is having an impact on persons seeking that licensure. And further, universities that have historically required eligible seniors to sit for the FE are questioning whether they need to or can continue to do that. So that's going to be another topic of discussion for us. And on that point, our representative on the grants committee might be talking with you, Mr. Lim, with the other committee members. Certainly this board exists for the protection of public health, safety, and welfare through licensure. And one of the discussion points yesterday was, should we avail grant money to universities that don't meld with our mission, I guess, and encouragement of licensure. So that will be something that committee will discuss, I'm sure, in the coming month. I had to leave the meeting a little early yesterday. John or any other engineering committee members, was there anything else we needed to tell? John, did you have anything else?
I guess we should mention, but mostly it was just interviewing applicants and application reviews for the remainder of the time. But the committee did briefly look at the policy regarding use of PE seal and review letters, and they felt that should be deferred to the October meeting when Ricky Bursai will be in attendance, since he actually drafted that policy. That was going to be presented perhaps for adoption today, but we're going to defer that to the October meeting. That was it.
Sure, that's our committee report.
Thank you, Hal. We'll move on to the Architect Committee report. We had a brief meeting this morning. We didn't have a whole lot of information to cover. We owe a response to NCARB regarding information that we reviewed when we were at the convention in Philadelphia. And basically, they're trying to streamline the intern development program and overhaul the whole program to make it a little more user-friendly and make it in line with a contemporary practice of architecture. So we agree with what they're trying to do, and we're going to communicate that in letter form to them. Second item we discussed was the broadly experienced architect changes. And as long as they meet our requirements in the state of Tennessee, we're not opposed to that. Education issue. And, you know, you have to have a formal education. Licensed in another state, you're not allowed. It's just the way the state law is. It's something that we probably might put on the table for discussion at our retreat. Is that something we want to address? Because not every state has that issue. And so a lot of they use the NCARB certificate as a means of getting licenses in other states. So that's just for conversation purposes only. And the third item was the, excuse me, broadly experienced foreign architect changes. What is it, John? ESA? Currently, when we review applications, if it's ESA, if they have identified that it meets requirements, then they qualify. And we're in favor of supporting this as well, as long as they meet our education requirements. So that's about it for what we had today. It was a pretty quick meeting. John made us get here at 8 o'clock. That's the report for the architects, or unless you guys have any other comments. Okay, and thank you. Move on to unfinished business, Mr. Cawthorn.
Page 97 on your iPads, you have the action items from the June meeting. And we're still working, of course, on filing the rulemaking hearing notice. It's currently under review. The FAQs on QBS have been uploaded on the board's website. Of course, they will also be published in our next newsletter. And I contacted David Smith. This was regarding a QBS issue that came up at the last meeting. And he indicated that he would prefer to speak to a board member regarding the issue rather than attending a board meeting. So Mr. Campbell volunteered to contact him. Mr. Campbell, did you want to report anything on that?
Yeah, and we discussed this yesterday in the engineer meeting, but I knew we were coming up on this part of it. I did meet with Mr. Smith. He's a general contractor with Johnson & Gallion. He's also an engineer, and they have several there. There have been questions that have come up from specifically the Public Building Authority in Knoxville, but I'm sure it's a question that will be asked by other similar entities. When you have a product that is stamped by an engineer, such as a specific, Steve mentioned Ross pre-stress, a concrete beam, or a particular item that you have in a building or in a application, and it's public funds, does that architect or engineer that stamps that have to go through the qualification-based selection process? And we discussed that, I think, for a little while at the engineering committee meeting. It's something that we believe we need to examine further because it's got design build implications. So if your contractor hires an engineer and architect in a design build and it's a public funds, do they also have to go through that process? We're looking at who the contract's based with and trying to determine if that's the delineating point. I think that was kind of our consensus. But we've asked John to go back and Rob, I think, and look a little bit more in depth at possibly what the Brooks Act says, because that's really the genesis of the entire QBS model, and what services are considered under that, and if there's a dividing line there, we certainly don't want to create another dividing line that's in contrast to that, and we don't want to complicate the issue. We're trying to find some simplified way to resolve that, and we don't want municipalities, and again, this is Robert's opinion. In this case, they're buying a product, it's contracted with the general contractor to go install. The contractor has been selected based on whatever. I'm not sure that engineer that's in a plant somewhere that they're making a specific thing needs to go through qualification based, because you have product liability and you have other things that go along with that. That being said, I don't know all the minutia of the law, and I would prefer that we look at those instances and get a little bit more information, because this really probably has some broader implications than just this one question, especially as we start looking at alternative delivery methods for construction projects and for public works projects. We need to make sure that whatever we do now is going to be consistent. It's going to be easy to use by the municipality, and obviously, most importantly, it's going to take our mission of protecting the public health, safety, and welfare where it needs to be. Something in place that makes us feel good about ourselves, but doesn't accomplish our mission. And I think that's a synopsis. But if you all can take care of that and give us a little bit more information just on the law, statutes, and what's included, not included, I think we'll have a little bit better.
There is a session at the NCEES annual meeting next week on QBS. I think it's going to be led by the California board, so we're hoping to get a lot of good information at that session on how other states are handling
I
QBS.
strongly suggest that everybody that can, there's an 8 o'clock and I think at 10:30 it's an encore for QBS. If you can attend one or the other, but both maybe, because they might have different attendees and we'll hear different issues. Also a class at the same time, I think ABET observer training.
Right.
Some of you may want to go to, but I'm hoping to learn something about QBS at this meeting next week. Especially California, you can only imagine what it's like in California.
Day is that on? Are we gonna?
Wednesday, yeah, the first day.
I would concur with Mr. Herndon, and just from my experience as an ABET observer, the only thing you need for an ABET observer is you need internet Wi-Fi connection so that you can surf websites, because all you really do is sit in the corner and listen to them. So that's just my opinion as an ABET. They don't let you do a whole lot.
So where are the QBS classes again?
Seattle,
Seattle?
Wednesday morning,
CWS
Okay.
annual meeting.
8 o'clock, and I think again at 10:30. I'm planning on going all morning, I have to say, and hopefully we can bring that package home with us and adopt a lot of it.
Might be an idea for make a suggestion to make for an in-car meeting as well. They might want to schedule something on QBS.
Yeah.
Yeah, it's be very helpful. I think we're not the only state dealing with these issues, I'm sure.
Obviously, because they've scheduled a seminar twice
Yeah.
at this annual meeting, so
I'll suggest that to NCARB, that they may want to consider that for their next year's annual meeting. And that concludes the action items. And I think QBS is the next item on the agenda.
Pardon me, Hal?
Just a little lightness here, not to out-nerd Laura, but.
Oh, try, just
the
try.
weird science facts on here, I'm a little troubled that the pencil has no length, girth, or anything, so I think that's a bit.
What number?
ambiguous there.
Maybe the
Well,
pencil's
yeah.
38 miles long.
I'm assuming it's a
Kind of
standard
knows.
pencil.
I think there's a
Number
ban
2.
or a protective case on fake flamingos, so I don't know that we can.
Endangered.
Yes.
A little bit more brevity. As I was driving up the interstate, there was actually a flatbed truck with huge fake flamingos on it. There were about 6 of them in the back of this truck that were probably 6-7 feet tall. So
It's on the way to your house.
anyway.
Yeah.
When you get home, they'll be there.
Okay. So are we through with our action items and the QBS comment on that?
No, not QBS.
Oh, okay, all right,
Yeah.
because we talked a little bit about it, I wasn't sure.
Yeah, we dealt a little bit with it. Beginning on page 98, these are the FAQs. That'll be familiar to you. I sent the FAQs that the board approved at the June meeting to the state architect, and I got a few comments from him that I thought I would share with you. I sent them to the state architect because they're dealing obviously with the same issues, and we're very interested in the board's position on some of these questions. Number 5, which is highlighted, does TCA 124107 apply to nonprofit organizations that receive public funds such as charter schools? And the answer is no, it applies only to contracts for professional services just quoting the statute, doesn't apply to private nonprofit organizations regardless of the source of funding. And the state architect suggested the board may want to advise that while TCA does not require the QBS selection in these instances, the conditions of the source of funding, such as a government grant, may still require QBS. So I thought that was a good point.
Yes, Laura.
Would that still be under our jurisdiction, though? Wouldn't that be the grant?
It would, I think he was just suggesting that we might want to put a note in
Like that
there that
note.
it's up
Okay.
to, whoever provides the grant. Also,
I think that's just a sentence that says, please check the grant guidelines for their QBS criteria. I think that would be suitable, something.
draft something and maybe represent it in October, some language for that. And number 16, can price be considered when selecting a design professional for a public project? He commented it has been questioned whether the qualified registrants have to be negotiated with in order after negotiations with the best qualified fail. The common answer has been that the second best qualified then becomes the best remaining qualified, and thus, yes, does the board wish to address this? First, negotiations fail with the first, should you go to the second, then to the third? Yeah.
I think that under I think the way QBS is written, if I'm not mistaken, that's, you go 1, 2, 3. And I know like for the city of Knoxville, I think you all have a 1, 2, 3. When I get something from purchasing and it says if we can't get a whatever with this person, we're going to this one, then we're going to that one. I think if I'm remembering right on those letters.
Well, that's correct, but I don't know how you could say you're using QBS if you don't do it that way. Because if you negotiate with number one and you've got 5 others, and then how would you pick the next one if it isn't based on QBS? So it seems obvious that that's how that needs to be done. Otherwise, you could say, well, my brother-in-law's number 3, so I'm going to skip on down to number 3. They really need to be ranked according to qualifications, and you go right down the list negotiating.
You said what I was going to say, yes.
And amend that question as well to address that issue. Okay.
Yes, sir, Mr. Lim.
Hey, John, when we get all this QBS all done, I think we need to reach out to our society, professional society, ask them, see whether they want to do some kind of seminar, a workshop. I think it's worth doing it and then count it as continuing education. I know Candice is here and Don's here. Rick just Nathan just left, but something's worth, because we work hard to, if we have questions among ourselves, I wonder how many registrants out there have questions. I'm not suggesting that the workshop will clear everything, but at least give a good basis for continuing education. What do you think, Candy?
We're doing that at the annual meeting.
Andy, would you like to speak?
There's an annual meeting. I think on the annual meeting.
I think that's a great idea, Philip, and we are having seminars in Knoxville, Nashville, and Memphis in December. That could be an afternoon session then, so that it would be more available to registrants who live outside of Nashville. Those who are coming to our engineers conference will have the opportunity to ask questions too, but for a presentation, it would be helpful to have it in different parts of the state, and I'd be glad to work with you on that.
Ready to travel, John?
That's what I needed, more travel. Thank you.
But he'll need your help, Philip,
I know.
Yes.
and Robert,
Yeah,
and
Memphis
Hal,
will need you
and
there,
Laura,
Philip.
and Steve.
I mean, I just think that every time we sweat through the bullet to getting anything out, it'd be a good continuing education learning process.
And I failed to make the point that architects come to these seminars in December too. It's something we do with AIA. So you would have both professions there. Now, we'd have to figure out how to get landscape architects to attend, but, we work with AIA too.
The December, do you have dates on that yet? Yes. And the only reason I ask is I think we've got a board meeting that's the same dates, or it has been in the last couple
Our
years,
board
I
meeting
believe.
is in first week of December.
And I think this is in the first week or so of December.
Yes, our dates, well, wait a second, now it's December 10th, 11th,
There it is.
and 12th.
Which city, which day?
Oh, that's for 20.
Knoxville, 10th, 11th, Nashville, Memphis, 12th.
Yeah, our board meeting's
week
the
before.
3rd through the 5th.
Okay.
So, yeah, we're good
Okay.
on that.
Okay.
Okay, we
Excellent.
will book it.
I think we should go ahead and book it.
I think in the last couple of years, though, they've been on the same date.
They have been, yes, they've been the first week, and I'm so glad it didn't conflict this time.
I'm early for us.
Okay, and we'd really like to have you guys there to help with the presentation, Jerome and Rick and Frank.
Western City can come.
To John, I mean, just as a
Good idea, too, in case it's questioned. Yeah, let's do it as a motion, yeah.
Could the motion be on a more broad basis? Because things come up, not just for those meetings. And the reason,
specific to QBS or any invitation to board members?
I think.
Well, I've been invited.
That's overly broad, yeah.
Oh.
I've been
probably.
invited to speak at Lipscomb, so I was going to ask for that separately.
Yeah, I would do it separately, I think, yeah.
Well, since we're on this subject, we, in Chattanooga on the 21st of the month, or the 28th, I can't remember the date, we're having the constitutional officers and several representatives from the University of Tennessee and TBR and STREAM and the state architect and various assorted senators and representatives to meet with the AIA statewide. I think you guys have gotten a blast on that, haven't you? You haven't got it, well, you should. To talk about regionalism and how historically the state has been structured in the 3 divisions and what it means to give a Memphis firm a project in Chattanooga, which has just recently happened with TDOT, that's never been the case in the state. And the regionalism thing seems to be declining, where if you're just an architect in the state, you can go anywhere and do the work. So we're having a discussion with them regarding what that means to the architects in those regions. You know,
Are you attending as an architect or?
I'm attending as an architect, but they invited me because I am on the board to help facilitate the meeting.
That sounds more like a professional society
Okay, it is.
issue,
It's
not-
AIA. I
it's
just wanted to
not a-
I just want to
not
make sure
an
I didn't need
issue of
approval for
concern
that.
directly to the board, so I would say
Okay.
that one you would just attend as an
But I
architect.
will be
but-
attending as an architect, but also a board member.
Yeah.
So my
Fine to do that,
comments
yeah.
will be from a professional standpoint, not a board standpoint.
Right, as long as you don't speak on behalf of the board.
Okay,
yeah,
that's fine.
There's no problem with that, yeah.
Rick, what's that date?
Jerry, I think it's August the 21st. I can pull it up. Yeah, go ahead.
My
I'm sorry.
motion, is it clear, Wanda? Is that okay, what I said for your purposes? So basically, it's specific to the 10.
Second, Hal's motion.
We have a motion and a second. All in favor signify by aye.
Aye.
Opposed? The motion carries.
Do we also need to do the September ACEC TSPE meeting? I move that representatives of the board attend the ACEC TSPE annual meeting.
Oh, that's right. She's in the search.
Oh, sorry.
I make a motion.
You can ask that somebody make
Let me
that
do it
motion.
since you're going to be there.
Told me
Hal.
to. I want the record to reflect. Sorry, Hal did.
I make a motion that we give authorization to Laura and Hal to attend on our behalf for the is it the QBS session that's going to happen on Friday afternoon as our representatives to the state ACEC, TSPE, and also eligible for reimbursement for travel to that meeting. Murfreesboro. I mean,
Second.
We have a motion and a second. Any additional comments regarding the motion? If none, all in favor signify by aye.
Aye.
All opposed, the same. Motion carries.
Mr. Chair.
Yes, I'm sorry, Hal.
No worries. So
I was looking down at my...
Well, in the past, I've been told it needs to be approved by the whole board at an open meeting, technically. But there are situations that arise, where we might not have time to do that prior. And I think they give us some leeway in situations like that. So I haven't gotten any firm guidance on it, but.
prefer just to keep it at this point simple.
Yeah, keep it to the open meetings, yeah.
I'm sorry, everyone. I have a motion.
Second.
Second, I have one question. Are you actually representing the board, or are you doing it as a professional society?
The board.
Okay, okay. I just wanted to...
Yeah, no problem.
All right, we have a motion and a second. All in favor signify by aye.
Aye.
Opposed, the same. The motion carries.
I think we're traveling too much, don't you? No, I'm just kidding. No. All right, I think that's all on QBS that I'm aware of. So.
Okay. Moving on to new business then? Is that right?
Page 103, you have the apprenticeship legislation that passed this year. This was some legislation that we were tracking, and now we've been informed that we need to begin working on our report that's required by this legislation. This bill, now Public Chapter 881, requires us to develop a plan to create an apprentice program to include but not be limited to the subjects of apprenticeship training, supervisory standards, occupational instruction, wages and benefits, licensure, and the role of the Division of Regulatory Boards in implementing and maintaining the program. And that's to be submitted to the Speaker of the Senate, Speaker of the House, Government Operations Committees, et cetera, on or before December 31st of this year. And the plan is that I'm working on drafting a response right now, but not nearly complete with that task. So the plan is we'll present sort of a rough draft at the October meeting, at which point we can all review it and discuss it together, make modifications, and hopefully approve that and send it on for submission to the authorities listed in the bill by the end of the year. And it will be reviewed, of course, within the department as well, in the division. But this plan does require us to submit information on any apprentice programs that are currently in effect or that were previously in effect, and provide data on number of persons participating in the program each year, program outcomes, including the percentage of program participants who've continued in their chosen fields, description of the program and its objectives, number of persons licensed from July 1, 2009 to July 1 of this year, number of persons employed in each profession for that same time period. So it's going to require an extensive amount of research, and that's complicated by the fact I'm not sure what the intent of this legislation is, this particular bill is, what they mean by apprentice program, because typically that's applied to trades, not to professions like engineering, architecture, law, medicine. It's not typically a term that you would apply to those professions. You would use internship, correct, for those professions, like in medicine, architecture, et cetera. And certainly for architects, we have a very structured internship program in IDP. The other professions, not so much, although we do have an interior design experience program for interior designers, but it's not mandated by our laws and rules. No, not for Tennessee. It's not. It may be by NCIDQ.
Right, it's
perhaps,
mandated
but
by NCIDQ.
CIDQ.
So my question is, do we need to tie this to our grant program? Because if it's being required by the state, do we need to look at it in terms of anybody that receives a grant?
But at
you
this
know?
point, it's not being required. It's
Okay.
just, we're just submitting a report.
Okay,
On, how we're developing a plan to create a program, but,
do we need to involve the schools and ask for their input?
well, my plan was that we will simply submit the IDP program as, essentially as our apprentice program for architects and our existing requirements, experience requirements for engineers, landscape architects, and interior designers, along with the IDEP program, which is optional for the other professions, and maintain that those programs essentially constitute an apprentice program for those professions and meet the intent of this particular bill. I'm not sure if the intent is that these apprentice programs would provide an avenue for individuals without the proper education to become licensed simply through experience, because historically an apprenticeship is education experience rolled into one. You don't have a formal academic education as part of an apprenticeship. That is your education. So I'm not sure if that's the intent. Recently, there was a bill affecting the Surveyors Board where if individuals had 10 years of experience working in surveying, right, Rob, they would be eligible for a surveying license without meeting the education requirements.
Without having a bachelor degree in it.
Yeah, without a bachelor's degree in surveying.
Constructively an apprentice program.
So I'm not sure if that's where they're going with this, if they're wanting us to develop a similar type program where, say, 10 years experience, they could receive a license without the required education.
The problem with the surveyor law said if you've practiced for 10 years, you're eligible. But the problem is, how do you practice without a license for 10 years? So if you practice for 9 years and 11 months, you get disciplined for unlicensed practice, but if you get to 10 years, then you can get a license. So, didn't really make a lot of sense. I've been trying to get that taken out of the law for a long time, but this time it just got worse. What they're thinking, and I don't know if this bill had anything to do with it or not. At least an average chance it did have something to do with it.
I'm not sure what the intent was. Regarding the wages and benefits, we have a standard answer for that. Wages and benefits will be determined between the apprentice and the supervisor and is allowable by state and federal law. So, I mean, we're obviously not going to dictate wages and benefits. That's outside the board's purview to do that. But the rest of it we'd have to respond to. Bill?
John, is there any way getting clarification on it? Because when you say apprentice, that is basically the trade, rather than a profession like the engineers, architects, interior designers, landscape architects, attorneys, doctors. And I'm just, if you could get some clarification as to,
It's a broad public chapter. We do license things like locksmiths and security guards at our trades. I mean, how do you have an apprentice accountant? Because we license accountants in this department as well. Is maybe they believe it to be, I don't know.
Right, you're right, the determination may be it doesn't really apply to our particular board, perhaps.
Maybe our answer.
Yeah, and I have talked to individuals in the division about it, and they're not 100% sure what the intent was, but I've been told that we probably should just respond, as I mentioned earlier, just explain what our current requirements are, go into detail on the IDP, IDEP, and the requirements and the rules for experience. And that should be our response at this time. And then if they come back and say, no, we want you to create a true apprenticeship program where you can be licensed solely through experience, then I'm sure that'll be communicated to us, and we'll go from
As
there.
you can understand, why would anybody want to go
John,
to school?
If I remember, my memory serves me correctly, part of the reason why for the engineer track, when after you get out of school, you get a FE, you call yourself EIT, engineering training. In itself, it is earning the apprenticeship. You are working under supervision of what they call the PE. In our term, we call it the sensei, the guru. So he goes through it, and then he goes through it, and then he has to validate his experience. The three-legged stool that we have is probably still pretty good. So I think that on the premises of that, I'd like to suggest at least to kind of let them educate them. Part of our job is to educate them. And what we are today is because 20, 30 years ago, somebody have a reason to develop the FE exam. And then a lot of my engineers nowadays, when I hired in the coming first 2 years, you ask them, what type of engineer? You says, I passed my FE, what do you call yourself? They have in a name tag called EIT, engineering training. And I think we should use that. Thank you.
This as engineers and architects, landscape architects and interior designers, we belong to national associations that create model law and rules. And I don't know if it's been thought of, but this kind of thing touches and concerns, as they say in the law, many different things. It could lift us out of, we would be the only state that doesn't comply with NCAAS model standards. It would create problems with reciprocity. And for our people, not for Tennessee, but our people, if they got a license that way, they couldn't go anywhere else because nobody would accept them. There's a lot of things to think about. I think Philip wants to.
It's just a thought that, if a person doesn't want to take a FE, our law and rules allow them to work progressively 12 years and be able to demonstrate that out of 12 years, at least 4 of those are supervised by PE and they have. And then we qualify them. So there's another avenue to actually bring people in to recognize the experience, bypass the FE track, and then take the exam. I think we got a good model. That's what I'm trying to say at the end of the day. I
And
told
for
somebody, I said,
engineers-
Tennessee has good law.
If for engineers, they can get a year experience credit for cooperative education programs.
Correct. That's
too,
another way
which
to, master's degree.
ties in with this, I believe.
I think we should tell them. Thank you, sir.
If you have any suggestions as to how I should respond, I certainly welcome those.
I think what you just said is a
Okay,
good response. This is how we're structured, and we have these national organizations that have training programs, however you want to list them, intern.
Internship.
Yeah, so I think just respond that that really doesn't apply to us in that particular way and see what they say.
Right. Yeah, it's not being mandated, we just have to do a report. But
Yeah.
yeah, we of course have to be careful in crafting the report to
Mhm.
make sure we address whatever concerns we perceive that they may have.
I can't help you on that. I can't write English.
Well, I will have a draft, for us to review in October, and I was thinking, of course, the agenda's a little later on the agenda. Maybe that could be one of our agenda items, have a session just to review the apprentice plan that we're going to present to the legislature.
Final point on that is, before we were interns, we were apprentices as architects, years and years. Got the internship in place with NCARB, and it changed. So they just changed the name. So.
All for that.
That it? All right, we'll move on to, I've got 30 minutes left, so, but we don't get done. Mr. Campbell will get done. Committee assignments, I copied out everyone on an email. I hope everyone got it, to ask if you wanted to be on any other committees. No one said they did. They said, I'm fine, a couple of them. And so my opinion is, if at the board's discretion, would be to leave the committees as they are, and unless you want to roll off of one or roll on to another one. So my recommendation is to,
I think I have to be on the finance committee since I'm secretary.
okay, well, all right,
So,
all right. Well,
Take my place.
no, you can stay on with us.
well, where are you going, Hal?
I'm on a couple of others.
Uh-huh.
I'm on continuing.
Hell.
Use your mic.
I heard you, but I don't think they did.
We got the fan going back here.
In response to Ms. Ballard's indication that in holding her new position, she needs to be or is required to be on the Finance Committee, I availed or offered to rotate off of that to allow her to take my place, upon which our chair questioned my integrity on the offer to rotate off. And I assured him that I felt still engaged, since I'm on the continuing ed, the interior design, and the engineering committees. But whatever he sees fit, I will comply with.
Actually, the bylaws, I think, state that the secretary is the chair of the finance committee. Yeah, I think it's in the bylaws.
Yeah, okay.
Bunny.
Not much
So
choice
she would take
there.
Mr. Campbell's place, or
Or just
can Mr.
assume
Campbell
the
stay on there for
chairmanship.
continuity purposes?
Yeah, Mr.
I think that would be a good idea.
For continuity, keep Mr. Campbell on there?
Yes.
All right.
See what your buddy's doing to you?
Well played, Mr. Chair?
Very good. very
Okay,
good.
thank you. I watched House of Cards, so.
Yeah, okay, that's a great one to watch. It's good. Are there any other adjustments we need to make to these committees? So, do we need a motion on this, or is this just chairman's assignment?
As chair, you can assign
Okay.
people.
So, all right, just for the record, Susan is going to be joining the Finance Committee as the chair, and Hal is going to roll off and not do much of anything else, but no, I'm just kidding. No, Hal, you're on enough committees, believe me, I know, I understand.
rolling off.
Yeah. You're still okay being a chair on the grants to higher education? Okay,
Yes.
all right, all right.
You can take me off of one of the others.
Well, unless someone wants to be off of a committee, then we're going to just leave them like they are.
You shouldn't have said that.
Okay, so that's my recommendation.
Very good.
All right. Next, October meeting agenda.
That's on page 107 on your iPads, where that begins. Will be October 8th through the 10th at Montgomery Bell. Right now, the draft agenda here, we've got the 4 licensure application review committees for the 4 professions meeting on Wednesday afternoon. That's what we've traditionally done, beginning at 1 o'clock. With the engineer committee getting the lion's share of the time because they tend to talk more than the other committees do. And if you have suggestions for items that you want to add, to the agendas for these committees, send those to me. Yeah,
3.5 hour committee.
Yeah, 3.5 hours. That won't be enough time for the engineers. And I am going to add to that, I think that would be the best time for us to probably try to schedule a meeting with some TDOT representatives to discuss experience. That afternoon would be a good time, I think, to schedule that, since we're meeting with the educators the next day and got a pretty full agenda for the following day. So, and that's solely concerns the engineers. So I'll try to schedule that. So we will need that amount of time, I'm sure. And Thursday morning, of course, we're meeting with the educators. And I have gotten a couple of responses from engineering deans about items to add to the agenda. They specifically wanted to add the update on computer-based testing and fundamentals of engineering exam changes to the agenda. So I've included those items for discussion in the breakout session with the engineering educators.
Don, I'd like to get the board's opinion. You know, we give the schools a lot of money, and it would be nice to see some of the work that the students are doing, be either photographs or presentation boards or something. You know, $300,000 every year, we ought to see something coming back out of that. So I'd just like to make a suggestion that we ask them to bring. They don't have to make a formal presentation, but if it's something they can stick on an easel and show us what they're doing with the funds that we're given, I think it's worth, asking them for.
I like the idea. I was going to actually bring it up that I know it's an open meeting. I know Candice and the other professional society comes. We should probably invite our members to start to interface with, because a lot of these professional like ACEC, TSP, people are looking for engineers too. And I think the dean can hear firsthand from us who are practitioners saying that, hey, this type of things, type of quality student are looking for, the type of things. For instance, passionately, just indulge me for a minute, I'm finding less and less of people teaching power system curriculum at the university level. So we're having to do a lot of in-house training. We bring people in, and I think that for the professional society to be there to at least let the dean understand that, hey, we are the one that ultimately hire your students. So pay attention to some of the things changes. So anyway, Candice, you want to add anything? I think it would be good for a professional society to at least have a part in meeting with the dean. I know you come to the meeting in the past too, right? Let them understand what I need. And I like Susan's idea about let them bring their favorite student or something like that, and just show and tell. Thank you.
If we do this, we got to go talk to them, okay? We can't just have them stand over there in the corner, so.
Oh, trust me, I will
We
talk
need
to
to have
them.
engagement with it. But I think, we're spending a lot of money. I think we ought to see what we're getting, the bang for a buck, so.
I've got to say that I've been very fortunate to be a member of the Civic Design Center in the UT course here, and the student work is really, really good from the architectural students and some of the landscape architectural programs. They're doing joint programs with the architects and the engineers and the landscape architects, and some of that work is just very high quality. And I've got to say that they're pulling out some really good students.
I think it's good for the schools to see what the other schools are doing too. Not necessarily from a competitive standpoint, but, if one program is not meeting the same level of work as another, they need to step their game up. So I think it's a good opportunity for them to see what's going on.
I would hope that the dean at Lipscomb will talk a lot about the recent ABAC accreditation. So if I were him, that's what I'd be talking about, highlight, bring some highlight. Good point, Susan.
Mr. Campbell.
John, the Wayne Wagner thing, is it going to be in the board meeting or is it a committee meeting? And
Yeah, it's not included on here, but it'll be at the board meeting on Friday. I don't think I've added it on here yet.
the QBS, did we decide to talk about QBS? Is that in the engineering committee meeting, or did we have something we just discussed to do that with?
That would probably be for the board meeting on Friday, but it could certainly be added to the agenda for the various committees as well to
I want to
discuss.
make sure that we have it slotted somewhere so that we.
Yeah, that may be gone. Yeah, we probably won't have the rulemaking hearing either, so that would be the slot for Wayne Wagner, I suppose.
Okay, fantastic, thank you.
Oh, just a suggestion on the meeting with the educators. Right now on the agenda, we have for the general session with all of them, a licensure outreach discussion and grants program discussion. Together, that adds up to an hour. But we could move the licensure outreach discussions perhaps to the breakout sessions, because that's usually when that's discussed more in depth. And maybe for that 1 hour time frame, that might be an opportunity where maybe the educators in attendance could report on how the grant funds are being put to use. I think that might be a good time slot for that.
Yeah.
And then they could, maybe give us a brief presentation on
Right.
how the funds are being utilized. So that might be a change there. Okay. Sound good?
John, I have a question on the page, the board member training, the review of Robert's Rules of Order and formal hearing training. Who's going to be presenting that?
I was getting into that. Yeah, that was just sort of a placeholder. We weren't really sure what to put there. I think, I was thinking that we could put that, a review of the apprentice plan in that slot, for us to review the draft and make any changes. Might be a good idea, unless you
But are
feel that
those-
needs to be still included on the agenda.
Well, I think the Robert's Rules of Order, it would be a good discussion. If you did formal hearing training, maybe that, I'm just throwing it out there. I'll have a little different opinion of Robert's Rules of Order, so.
Since we don't follow Robert's rules, why are we going to be, we've been trained on them 4 times.
I know.
Nobody
Yeah.
pays any attention, so.
Well, there were suggestions. No,
Right. So would you rather have the review of the apprentice plan there, or what's
Yes.
the pleasure?
Yes, Mr. Paul.
Perhaps an informal Robert's Rules reminder session during a happy hour,
Yeah, there you go.
sponsored by the architects.
Fair enough.
They're not happy. Why should they be happy?
They're always happy.
Really?
We may not remember the discussions that we had.
Are you happy, sir?
Yes, I am.
Okay, thank you.
John, is the session on Friday, what time is that anticipated?
I would
Before lunch?
It should be done before lunch.
Okay, thank you.
Yeah. By then, everybody, even Hal, will be tired of talking. Just kidding.
Wait a minute. 1 year we had a chicken is sitting in the chair. Howard was not there, remember?
That's right. I thought it was a lamb.
It was a lamb. It was. We'll have to do another group photo.
Rick?
Yes, I'm sorry. Laura.
That's okay. Just back on the QBS real briefly for October, since we're going to NCEES and we're going to be all educated on the law, I want to make sure we're kind of all talking together about this. We talked about talking in the individual committees and then talking as a board. I just want some thought put into when are we going to report back what we learn at NCEES at some point to the whole group, and bring that to some discussion. I mean, some sequence of how we're doing this would probably be helpful for October.
Yeah, there is a report on the NCEES meeting on the agenda, but it's later on the agenda. So, yeah, perhaps.
That's a report on the meeting in general.
Yeah, it is. Perhaps we should have a session just on QBS added to the agenda. I mean, honestly, right now, I don't have that many law or rule changes for discussion. I mean, we have a few to be discussed. We have a Law and Rules Policies Committee meeting. I'm not 100% sure that one's necessary. Also, Finance Committee, Publications Committee. I mean, we could maybe remove one of those and put a QBS discussion in that slot, if you think that would be appropriate. Licensure outreach.
That's what I'm thinking. We add that. Give us a little bit longer time of licensure outreach. So then we'll talk about the QBS. Our policy, law.
Not to take anything away from the Publications Committee, but that wouldn't take very long to get caught up on that, would it? I mean, do we need to do it?
Evens the chair.
Hey, I wrote one, but I think Bill did a great job of filling in for me in your landscape. So,
I know particularly the Continuing Education Committee, I don't have any rule changes for them to discuss. So I'm not sure that they really need to meet unless, maybe Frank had some ideas for discussion.
I have no ideas.
But we might could eliminate and shorten some things, and we could squeeze in some time before the review of the apprentice plan to discuss QBS specifically. Might be a good idea.
you set the schedule, we'll go by it.
Okay. It's at my discretion, right?
Your discretion.
Okay. On page 112, you have the 2015 meeting calendar with dates of other events as well, some of which are tentative at this point. The meeting dates for our committee and board meetings would need to be voted on by the board.
Always the second week of each, except December, is that correct?
December and June for next year. The June meeting had to be moved back a week or forward a week, whatever. Had to be moved because of the CMA Music Festival. That's scheduled for the week that we normally meet in June, the following week. So I had to move the date for that. So June and December are going to be the first week, and the others are the second, right?
A motion that we accept the proposed 2015 meeting agenda, schedule, excuse me.
Second.
Motion and a second. Any additional conversation or remarks? If none, all in favor signify by saying aye.
Aye.
Opposed, the same. The motion carries.
Sorry,
Go ahead.
Mr. Chairman.
Go ahead.
When I saw the schedule, something else came up. We are hosting the Southern Zone meeting in 2016. When do we need to have a discussion about that internally? And I don't know if it's at the board meeting, at the retreat, or is it something we do in 2015? I just want to make sure that we've got time to do what we need to do.
Yeah, we've still got time, plenty of
Okay.
time for that. They're not doing the, the detailed planning at this point. Right now, I've got to follow up. I know that they were going to reserve or enter into a contract with the Lowe's Vanderbilt Hotel for that meeting. I don't know for sure if they've entered into a contract yet or not. I haven't heard back on that. So we found the location for the meeting. That's the first step. And yeah, we are going to be, of course, involved in planning other activities involved with that meeting. But that's a little early to discuss those
I
details.
didn't know when the timing was on that.
Yeah.
Thank you.
Yeah, I'll let you know when we need to begin discussions on that. And of course, we'll be working with the Surveyors Board on that as well, so it's more of a joint project. Move on to the NCARB report? Okay. Page 113, you have a report on the NCARB annual meeting in Philadelphia. Very important meeting because a lot of changes were presented for consideration, including proposed changes to the broadly experienced architect and broadly experienced foreign architect programs. Basically, the proposed path for broadly experienced architect would be that the applicant would have to meet a board's education and experience requirements for initial licensure, pass the ARE, and obtain 1 year of licensed practice. Currently, they have to wait 6 to 10 years after licensure, depending on their education background, to apply for certification through that program. And also the BEFA program would be altered, where applicants would need to meet the education requirements for licensure in the home country, be licensed or credentialed in the home country, have 2 years of licensed practice in the home country or the U.S., pass the ARE, and it would eliminate the experience dossier and review that's currently included in that process. And also, that it would, my understanding is it'll greatly reduce the cost of those programs, because they're no longer going to have the interviews as part of that certification program. And these changes are going to require a vote by the council, so this will be, I'm assuming, a resolution at the upcoming annual meeting for 2015. There's also several proposed IDP changes. One proposal is to reduce the total number of hours from 5,600 to the 3,740, just focusing on the core hours and eliminating elective hours. And also modifying the framework. This is a second phase that would be implemented. Modifying the framework to reduce the experience areas to 6 areas corresponding to the 6 divisions of the new upcoming version of the ARE 5.0. Currently, there are 17 experience areas, so it's really going to streamline the program and reduce its complexity. And that's going to be voted on by the NCAR Board of Directors after a comment period, and as it was reported earlier, the Architect Committee discussed these proposed changes and agrees with them, and we will notify NCARB of their consensus on that issue. And those could be implemented beginning next year. Also, the Board of Directors recently approved a change to IDP to allow interns to earn partial IDP credit for valid work experience not previously reported within the 6-month time frame specified by the reporting requirement. That became effective on July 1st. That we received a report on the transition to the next version of the ARE, version 5.0. And in contrast to the last transition, NCARB is providing really very good advance notice of the upcoming changes, a very clear transition plan and recommendations for candidates as to how to go about the transition. So I think they're doing an excellent job educating interns as how they prepare for the transition. We also received a report on some improvements to the ARE, that the retesting window has been reduced from 6 months to 60 days, and they can test up to 3 times a year for a particular division. NCARB President Dale McKinney is forming a future title task force to review the terminology used for those who are architect candidates and who are licensed architects, such as, should they be called architect interns, or what are some other architects in training. I'm not sure what all the different titles are, but they're studying that issue. And the licensure task force is continuing to study a proposal for an additional path to licensure upon graduation that would incorporate IDP and the ARE into architectural programs. Several resolutions were voted on. The most significant one was Resolution 2014-05, which amends the bylaws to the effect that effective March 1st, 2017, all regional directors and officers must hold an active NCARB certificate. So that was debated extensively, but it passed. Future meetings. The next regional meeting is scheduled for March of next year in Long Beach, California, and the annual meeting is scheduled for June 17th to the 20th in New Orleans, or Nolans, or however you want to say it. And that concludes the report, unless the architects have anything to add. I
guess the next thing on the agenda is the adjournment of this meeting.
So moved.
Hold on, we have a comment from Philip.
I do need to see the board after the board member after we adjourn, because I need to do something unofficially about our refreshment. So thank you.
One
Yes,
for quick thing, foreign, we were going to do something with the Japanese and that foreign thing is that on our October or? is
That'll
that-
be deferred to October.
Taiwan, though.
And that, we can't complete that task until the residency requirements rule is repealed, which is still pending. So, until
That
that's
just
done, we
triggered
can't do
my thought
much.
on that.
but-
Sorry about that.
Yeah,
Okay.
it will be on the October agenda. though.
Chairman, make motion to adjourn the meeting?
Have a motion to adjourn the meeting?
Second.
A second. All in favor, say aye.
Aye.
Opposed? No.
Yeah, are we still recording?
Sicker rules.
I need to say that I want to thank the staff.
Wait a minute, she's going back.
Yeah.
No, no,
Okay,
it
hold
wasn't included. No. It's actually, it's been authorized.